Hi, good afternoon, and thank you for joining us for the next in our virtual Lunch and Learns presented by the Van Winkle Law Firm. These will be continuing until November 19th. My name is Koral Alman. I'm joined today with Steve Grabenstein, and we are speaking about resolving estate disputes both before and after someone dies. As an initial matter, if you have not yet voted, please pause this video and go vote. This video, along with all of the others that we have done and will do, will be on the Van Winkle Law Firm's Facebook page. So you can come back and watch after you've done your civic duty. But the most important thing right now is for you to get out there and vote.
So Koral and I both practiced with the Van Winkle Law Firm. Our practices are a little bit different. Koral is on the planning and administration side of the trusts and estates world. And even though I'm in the trusts and estates world, I tend to get involved when things go off the tracks. So I'm involved in either litigation, mediation, dispute resolution, etc., involving trust and estate matters. Today, we're going to focus on two topics that can overlap both the administrative side of things and the dispute or litigation side of things. And those are the use of family settlement agreements and the use of living probate.
Well, and before we get going into the substantive materials, we do want to say that today's discussion is about North Carolina law generally and our personal experiences in our practice. It's not intended to be legal advice, and it should not be taken as a recommendation for any particular situation. These sort of situations, when we're dealing with disputes either before someone dies or after someone dies, are incredibly fact specific. So as always, you should reach out to an attorney, preferably one with the Van Winkle Law Firm, and we can talk through the specific circumstances of your situation.
So with that profound disclaimer out of the way, Koral, let's talk a little bit about what's the context in which we might be looking at either a family settlement agreement or, I guess as a prelude, why someone might consider living probate to avoid some of these issues.
Right.
And what we have had some conversation on in prior Lunch and Learn presentations involved what is known as non-probate assets, where individuals might have IRAs, 401ks, bank accounts that might be joint with right of survivorship or payable on death, where there's a designated beneficiary on an account. That's all non-probate assets. And that means that if there's a provision in somebody's will that says, I leave all of my property to my son, John, if son John is not the designated beneficiary on those non-probate assets, son John doesn't get what's in those non-probate assets. And oftentimes son John is very irritated, upset, wants to talk with a lawyer about, wait a minute, clearly mom, dad, or whoever had a strong preference for me because they named me in the will. What's up with all these beneficiary designations? And if there's some reason to question the validity of those beneficiary designations, or if there's some confusion about the execution of some of those documents, you may well have a scenario that could lead to a family settlement agreement being a helpful and valuable tool.
Right, and the other sort of situation that we often see dealing with the disposition of certain assets is when someone's will or document, their trust perhaps, dictates that certain individuals are going to receive like a category of assets, but these beneficiaries aren't really getting along very well, and they're having a really hard time figuring out what of these assets each of them is going to receive. So as an example, you could think of a will that says, my tangible personal property, my furniture, furnishings, personal effects, vehicles, jewelry, all the stuff in your house is going to be split among my 3 children. But if those kids don't actually get along, who's getting the car? You know, ideally, you probably don't want 3 people owning the same vehicle. And if the values of those things can be very disparate, you've got a very expensive car, but you got kind of not a whole lot of other stuff left in the house. Someone's been in assisted living and they no longer own a whole lot. It's not an uncommon situation when we're trying to assist people in figuring out exactly who is getting what and sort of mediating that conversation to make sure we're still splitting things even Stevens, each are getting a third, but in what manner? Is someone getting a big item? Is someone getting a lot of smaller items, and getting values agreed to about those things? And that's another situation where we often use a family settlement agreement is we basically outline exactly how those assets are going to be divvied up.
Conflict avoidance, that's the key with a family settlement agreement. And we'll talk about that further. But Koral, as you know, one of the big areas, at least in my practice, where these agreements come into play is when you do have a will, or it could actually be a trust. Doesn't always have to be a will. It could be a will or a trust that is being challenged by a family member, disgruntled beneficiary, somebody that thought they were going to inherit, but turns out they don't. They're going to challenge that document, and 9 times out of 10, as we've discussed in one of our prior episodes, those challenges are based on lack of testamentary capacity or undue influence. Those are very fact-intensive cases. They involve an awful lot of discovery if you get into litigation. So the time and expense of fleshing those out, everybody's very eager and hot at the beginning of those cases. And then once they realize, oh, this is a 12 to 18 month ordeal that I've embarked on, they start looking for ways to resolve differences, and family settlement agreements are key in cases centered around lack of testamentary capacity or claims of undue influence.
Right. And today we're going to talk about 2 potential solutions to these types of disputes that we've sort of just walked through. The first is the family settlement agreement, which we've talked about abstractly so far, and we'll go into some more detail about shortly. That's something that we use after someone has died. The other alternative that we'll be talking about today is a living probate proceeding, which is an option prior to someone's death. And just as a quick aside, there's some terminology that we'll be using today that I'll just touch on very briefly. The first is the concept of a testator, and that is the person that is writing a will. In the circumstances that we're talking about today, they would either be the deceased individual, if we're dealing with a family settlement agreement, or the individual who is trying to avoid some sort of conflict with a living probate proceeding. And the other concept or term I want to touch on is a caveat, and that is essentially, in layman's terms, a will contest. And that's the thing that we're potentially either dealing with after someone has died, or that we are attempting to avoid by doing it in advance with the living probate proceeding.
Yeah, so maybe that's a good place to start getting into a little more detail. Let's focus first on the family settlement agreement. You know, what is a family settlement agreement? And it is, as the name applies, it's an agreement. It's usually an agreement that is the result of negotiations between competing, conflicting factions of either a family or extended family over a will, over a trust, whatever it may be. Whether it's through direct negotiations, whether it's through mediation, the parties have come to some agreement on the division of assets where they've agreed to set aside whatever it is that brought them to this point. And that's, okay, you're claiming mom lacked capacity, we disagree. We're going to set that aside, and we're going to put together in a written document our agreement on how mom and dad's assets are going to be divided, or the assets in an estate or a trust will be divided. So it's a legal document prepared by attorneys reflecting the agreement amongst all parties regarding the distribution of all of the assets that are being fought over, and agreeing this is the end of our dispute. We're going to release all claims that we have. We're going to put this to bed once and for all, and we're going to allow the administration of the trust or the estate to go forward. It's a great tool. It can be very broad. It could be very narrow. You've mentioned in your remarks earlier, Koral, you might just have a very narrow dispute over who gets what personal property. So it doesn't necessarily have to be a broad sweeping agreement. But if whether it's broad or narrow, I think it's a great device that helps parties post-death avoid litigation. And litigation, I tell this to all my clients, the party that's going to benefit the most in litigation is me, because you're going to be paying attorney's fees. And that is usually not what the testator, the decedent, would want. So a family settlement agreement, the formal written agreement, allows people to avoid the time, the expense, and the emotional turmoil that comes with litigation. And I think it's safe to say it would be a best practice to focus on using a family settlement agreement if you can in a will contest or a dispute over a trust or an estate.
Mm-hmm. And it's important to recognize that the family settlement agreement is one of only two ways that you can resolve a will contest. The other is by taking it to trial and getting a verdict on it. The other nuance to it that you've sort of touched on is that this is both a solution to litigation. If you've already filed a will contest and you guys are already in the midst of that, this can be a way to avoid having to take it all the way to that finish line of getting a jury verdict. But it's also, as you mentioned, an excellent tool to kind of avoid having to get that far in the process. If you know that you guys can get to some sort of agreement, there's some procedural things we might need to do, like filing a declaratory, a deck action and getting us in the position that we can actually get everyone to sign off on it. And I know you're going to touch on that in a second, but it's really important on both sides of the coin. The other thing I want to touch on is the fact that it's effective to the extent we can get everyone to sign off on it. So we're talking about all the beneficiaries, we're talking about the executor, we're talking about the trustee, if there's a trust, if there's like an IRA that's named different beneficiaries, and we're including that in our discussion, we need to make sure that the individuals named or entities named from the IRA are included. And we really want everyone to sign off on what is going to happen, how it is going to happen, and how they're all going to contribute to effectuating that plan, whether it's signing documents, signing receipts, or whatever.
That's a key point, Koral, because the effectiveness of a family settlement agreement is only as broad as the parties that sign it. So if you know in a will contest case that there's some heir who's not been joined in the will contest, you better run the family settlement agreement by them. Now, there is a little bit of an asterisk we can put on that, a change in the legislature several years ago with caveats basically says that if a party elects not to become involved in a caveat proceeding, they're going to be bound by the outcome of the proceeding, whether by a jury trial or by a settlement agreement. But nonetheless, the better practice is still to get everybody that you can to sign. And once you've got all of those agreements, all those signatures on your agreement, what you're going to have to do more often than not, and it certainly is a requirement, statutory requirement when you're in a will contest situation, is you're going to have to go before a superior court judge to get the judge to actually review and approve the family settlement agreement. That's less of a requirement when you're dealing with trusts, but I think if you're dealing with or talking with attorneys that deal with these kind of cases, and you've got a family settlement agreement and it's not a will contest, the odds are we're still going to ask for court approval because it adds another layer of protection to a resolution of a contentious situation. There is one interesting quirk, Koral, that's worth mentioning, and that is many of us were frustrated years ago when you could see an estate situation that would lend itself to a will contest.
Mm-hmm.
But the parties knew that there would be considerable cost in pursuing that litigation. They didn't want to have the strife and whatnot. So sometimes they would participate in mediation before a suit was filed, pre-litigation mediation, and that would lead to a family settlement agreement. Well, who approves that? Because you're not in superior court. So the legislature, in a very odd change a few years ago, inserted a provision in the statute saying the clerk of court can approve family settlement agreements. That was great. But that same statute says, however, the clerk may not enter an order which changes the dispositive provisions of a will, which is precisely what gets done in 99% of all family settlement agreements. So what we do to try to deal with that situation is we still encourage pre-litigation resolution of cases if we can get there. But what we'll then do is file a motion with the clerk in the estate of the decedent and say, look, we've reached this family settlement agreement. It changes the dispositive provisions of the will. We know you don't have authority to approve this. Please enter an order sending this up to a superior court judge so that judge can review this family settlement agreement and hopefully approve it. That's a little bit going in the weeds, but it's an interesting quirk that we have to deal with.
Right. So let's talk a little bit about maybe a hypothetical situation where we might use a family settlement agreement. So we've kind of talked about a couple of different reasons why you might need one. So you might have a situation where there's tangible personal property, maybe including a valuable asset like a car. And then you've also got like a brokerage account that was owned by the testator, the now deceased individual, and maybe a bank account. And the will says everything's supposed to be split among my two children, even Stephen's. But let's say maybe her daughter was acting as the agent under a power of attorney and for convenience purposes was added as a joint owner so that she could help Momma sell stock, raise cash as she needed it, etc. Now we have that exact situation that you talked about before, Steve, where what the will is saying we're doing, or a trust is saying we're doing, is not what is going to happen based upon the beneficiary designations on the actual account. And now it's causing all this turmoil in the family, and brother wants that car, but now sister's mad that he's, raising hay about the brokerage account. And this is exactly the sort of situation where either after litigation has started, we try to resolve it, but ideally if we can kind of get out ahead of it, we might try to pursue a family settlement agreement to address the fact that the brokerage account was really intended to be part of her estate and be split 50-50, but maybe sister was added to it for the sole purpose of facilitating the transactions, or it was some sort of hiccup when she was trying to get added as an agent on the account. The brokerage account didn't understand what they were doing. There's all manner of ways that we could end up in a situation where what was intended and what is, appears to be how it's going to be handled aren't the same. And by putting together a family settlement agreement, we can deal with that car. Brother can get that. We equalize with cash from the checking, whatever it might be. However, the siblings and all of the other beneficiaries sort it out by documenting it and then working through those processes you've talked about and getting clerk and judicial approval. We can kind of wrap this up and fix what could be an otherwise messy situation.
And Koral, I think it's important to note that, folks listening to this might be going, well, wow, that's almost like a magic wand.
Right.
That I don't like mom's will. I wanted to get this instead of that. Let's just use one of these family settlement agreements and rewrite the will.
Right.
You can't do that. Family settlement agreements just can't be written whenever people feel like rewriting somebody's will. That's just not allowed. Family settlement agreements are appropriate and warranted when there is a bona fide dispute with regard to an estate or a trust or what have you. If you don't have a bona fide dispute, you can't use a family settlement agreement to rewrite a will that you don't want. It's not permissible. It's not allowed. And we also, I don't think, should look at family settlement agreements as a proactive solution, because as we've been saying, this is after the fact that somebody's already passed away, conflict has arisen, and a family settlement agreement helps us resolve those bona fide disputes. But Koral, wait, isn't there something in the law that can be used?
If only there is the living probate proceeding, which is the second portion of our presentation today. So in addition to having, ensuring that you have effective estate planning on the front end of making sure that all of your ducks are in a row as far as beneficiary designations and thoughtful consideration of who you want to serve as fiduciaries in all of these different roles, we do have a proceeding or procedure that can sort of shake out these issues prior to an individual's death, and that's the living probate proceeding. So it's essentially a procedure in which we are probating someone's will or proving their will while they are still alive. Generally speaking, you probate a will after someone has passed, and basically what we're doing is shifting the timetable for this forward to have it occur while the testator or the individual who's written the will is still alive. By shifting that timetable, we now have significantly better evidence as to the testator's capacity, intention, what their ideas as to why this is their estate plan. Is so-and-so going to be taken care of by some other means, and that's why I'm leaving Johnny out of the will. We have the testator's own testimony to present as evidence as to what's going on, and that can address both capacity issues, whether or not the individual has capacity to actually make this will in the manner that they are, and it can also address any concerns we might have about coercion or undue influence from outsiders.
Yeah, and this statute, which allows for living probate, is it's relatively recent, been around for about 5 years. And it's really for an individual who has some worry or some concern that the will that I have might be challenged after my passing, and I'm going to try to nip that in the bud while I'm alive. So in essence, it looks very much like a caveat proceeding. And why might somebody do it? I think you've touched on it, Koral, that you know that there's a member of your family that is likely going to say you lack capacity or were being influenced. Well, you want to go through living probate, you've got the opportunity to tell that person, put up or shut up, if they are going to raise that challenge, you're going to do it while I'm alive. And hopefully you come out of the proceeding with the will upheld, and your plans are in place. So it can help establish, where you want to be at a point in time while you're still alive, and it really can cut off attacks. And it's a good tool for those who are pretty darn sure that an attack on their will is going to be made. So what does it look like, Koral? What's a living probate look like?
Right. Well, as we've talked about, it's essentially exactly the same as what we'd be doing with a will contest or a caveat proceeding after someone has passed, but we've just shifted the timetable up. And now we're kind of gonna keep harping on this issue of joining necessary individuals to the proceeding. We talked about with the family settlement agreement, making sure that you you may not need to, but it's probably best practice to get everyone on board to sign that agreement. And similarly, when we're talking about a living probate proceeding, we want to make sure that we are including as parties to that action anyone who we have concerns about raising a potential will contest down the line. To the extent that those people are added to the proceeding now during your lifetime, during the living probate proceeding, and if that will is found to be valid pursuant to that proceeding, they are bound by that determination. But we kind of talked about this before. If you left out someone and then they come out of the woodwork later and they were not included in that living probate proceeding, they're not bound to its determination as to its validity. So if you're thinking about who you might want to be joining to that proceeding, we're thinking anyone who's a current beneficiary of your will, anyone who is a beneficiary of a prior version of your will, your next of kin or your heirs, the people who would take pursuant to our intestacy statute, which we talked about, I think, in an earlier Lunch and Learn. Basically, anyone who might have a vested interest or a perceived interest in receiving something from your estate. The more people you've added, the fewer people that could bring it up on the back end. But usually if you're in this sort of situation we're talking about, we know who the troublemaker is going to be, and we need to make sure that he or she is included in that proceeding.
Yeah, because the net effect is you're not likely to undertake living probate if there are any questions about lack of capacity or undue influence. It's somebody who's saying, I'm fit as a fiddle, sharp as a tack, I know what I'm doing, and I'm not going to abide by somebody challenging my will. And so if you go through the process, you give that notice, and you prevail, you are effectively barring those discontented members of your family or friends or whoever they may be from challenging your will after your death. So it's a great tool in that way. One area, Koral, that I don't say I'm worried about it, but it's certainly gotten my attention is in living probate, you're probating the will that you've drafted. And maybe you've done that at an age and then your circumstances change 3 or 4 years down the road, and you're going to make a new will, because you can revoke a will at any time. So how does that work, Koral, in terms of if I want to revoke the will that I took through the living probate process, can I do that?
Right. Well, and North Carolina is kind of unique in how the statute is prepared or drafted in terms of the ability of the testator to either revise their will, as in make a new will, or revoke the prior will that's now been judicially determined to be valid. In some states, that's pretty much like the end of the line, and you have to do an entirely new living probate proceeding in order to get an additional will, you basically to overcome that one. In North Carolina, we have both options. You can have on the motion of a party a requirement that any future will has to be presented through a living probate process, or the ability to revoke the will would have to go through that procedure as well. Or they could elect, if no one raises the issue, you could revise your will in the same manner that you and I would revise our will. We just do it. We write a will, we sign it, we get it witnessed properly, and that's now the new will. So we had talked a little bit about this offline, you and I, about there's going to be some, because of the novelty of the statute, we're only 5 years in, we're going to really see some interesting case law, I'm sure, over the next couple of years as to how are the courts actually interpreting these things, what's happening when someone does actually try to revise or revoke their will if they've not, it's not mandated that they proceed with a living probate. There's all sorts of nuance that we haven't yet sussed out because the statute's just too new for us to really understand.
Yeah, I think the best we can say, given the absence of appellate court decisions on living probate, is it's a tool in the toolbox that you should talk about with your lawyer. And it's like all of the topics we've covered in this series is, we could go on and on and on in great depth about these issues. They're interesting, they're fascinating, and they come into play in a host of circumstances. But we don't really have the time to do that here today. So I think our primary takeaway is post-death, you got a conflict over whatever issue it may be. Bear in mind and remember, and hopefully you've got a lawyer, hopefully from the Van Winkle Law Firm, who's going to remind you that there's a tool out there called the Family Settlement Agreement that we can use if we can get the parties talking and work towards a resolution of whatever the dispute may be. Great for post-death. If the testator is still living, we've mentioned the other tool in the toolbox, and that is living probate. That's something relatively new, but may well be valuable in a specific circumstance if somebody is pretty darn certain there's a will contest coming down the road and they just want to have the peace of mind before they pass away that that's not going to go anywhere. Living probate allows you to do that. So I think, Koral, we may be out of time.
We are.
We covered the waterfront. So thanks for everybody for listening and joining us here today. We've got how many more of these left? 4 or 5?
I think we have 4 more left, and the next one will be next Tuesday, dealing with advanced medical directives and healthcare powers of attorney.
I can't wait.
Yes, tune in then.
Yeah. Thanks, Koral.
No vote.